Representative Romero. And you have two instruments. This is going to be on HB 83. Welcome to the Committee on Education. After we get the table wiped off a little bit for you there.
I bring to you this morning HB 83.
On your bill.
This bill is a collaboration between myself, Chairman Garofalo, as well as the Attorney General's office and his staff. It will provide for judicial review of certain student discipline cases, requires public school governing authorities to develop protocol for discipline of students participating in online instruction. And primarily, this bill provides a way for policy to be set that separates the school setting from a home or virtual setting. So HB 83, with so many school districts using virtual learning away from the school campus, we saw a need to require policy changes for the teachers and administration, as well as for the students and their families. Since the beginning of the COVID crisis, there has been cases involving students and teachers that have put both in difficult situations. Some students have been expelled or suspended for doing what would be considered normal at home. This bill would address those issues and require policies to be developed for students and teachers in a virtual environment. It will also provide a path for students and their families to appeal a decision that might have a lasting effect on a student as well as their record. It is my hope that through testimony you will hear today that the committee will agree that there is serious need for this valuable legislation. And I'd ask Representative Garofalo or Mr. Chairman, there are people in the audience that we know want to testify. So
Sure.
in the matter of time, maybe we'd go straight to them.
I appreciate that very much.
I'll come back afterwards and answer any questions that you might have if they're not answered with the testimony.
And let me just add, members, that I want to thank Representative Romero for taking the lead on this issue, and I want to thank Attorney General Landry, the Solicitor General Liz Murrell, who's here that will testify today, all of their staff that's worked with us very closely, and I want to thank Mr. Harrison and Camara for coming today to testify. And with that, let me read a few cards and see if we can come up with a good plan of action here. Let's bring up Mr. Harrison, if you don't mind, coming to the table. And you want to come to the table with him, Ms. Cusimano? Sorry, under normal circumstances, we would have had three chairs at the table, but if there you go. Take your time, Camara. We're all your friends here, buddy. Trust me. How you doing today?
Okay, I'm Camara Harrison from Jefferson Parish School. I'm a fourth grader. My favorite subject's math. I like basketball. LeBron James is my favorite player.
That's awesome. And you had a little problem with.
This is my favorite subject, and I thank you for coming here to listen to me, Miss Chelsea, and my dad's story.
Excellent. You had a little problem with your online instruction and with something that happened with you were trying to do the right thing with your little brother when he tripped over a gun. Did I understand that correctly?
Yes.
Okay, and you were just trying to do the right thing by helping your little brother picking up the gun, and so that he wouldn't get hurt, you wouldn't get hurt, and you were just trying to get it out of the way. That's what I've heard is it happened. Is that what you believe happened as well?
Yes.
Okay, we really appreciate you. You're growing up quick, and you're doing a great job today. We appreciate you coming to testify. I know it's been a lot of angst for you and your family, and hopefully we can get something changed about that today. Mr. Harrison, you want to add anything to what Camara said?
Yes, sir. Good morning, everyone. Thanks for coming. My name is Tyranny Harrison. I'm the father of Camara Harrison. I was born and raised in New Orleans, Louisiana, and El Jazz on the west bank of New Orleans. I have 5 children. We live in a 3-bedroom home. My 3 older kids do virtual learning, and my 2 younger twins that are 5-year-old, they actually go to physical school now. They started off doing virtual learning, but it wasn't working out due to the teacher having to teach the little kids in class as well as online, and it just worked better if the little kids went to class and whatnot. But what took place on September 11 was my son was taking a test, a rollover from the day before, and his computer was on mute as he was instructed to do so by his mother, who was at the house, and his teacher, Ms. Williams, who was on his virtual class learning. I was in El Jazz Point at the time. We live in Romero. I was in El Jazz Point at the time taking care of my grandfather, who suffers from dementia. So when I received the call that Camara was supposedly acting up in class, I immediately went home to tend to the situation because I knew the seriousness of a black child having a firearm or, exposing the firearm to a classroom session, and whatnot, When I made it home, I spoke with Camara, to get answers of what was going on, Camara was pleading with me to hear his side of the story, And I listened to my son, and he told me what happened. And as soon as he finished talking, my fiance, his mother, walked behind me with the phone to speak with his teacher. And his teacher basically told me the same story that he told me. He was taking his test from the day before. His little brother walked in the room, my 8-year-old son, Kagan, and he was on his physical education break. My children's break times, they are at different, their schedules are not the same, So my 8-year-old son, he knocks over the toy Daisy BB gun that's in the room that they share, 3 brothers share together. Camara responsibly picked the gun up and moved it to another side, and it was seen on the screen as he did so, as he told me in his story that he told me. And when I got the phone, Ms. Williams, his teacher, she told me the same thing that happened, And from there, I was in a bad position because my son didn't do anything wrong, but yet I had to discipline him or treat him as if he did something wrong according to the school, And from there, I spoke with Ms. Williams, I spoke with the interventionist behavior teacher, and I also spoke with the principal, who all gave me the same story that Camara gave me. But according to them, Camara did something wrong, and they were treating it as if he physically brought an illegal firearm to school, And I informed them that I disagreed, and I would be willing to discuss it at the hearing, and as to why I disagreed, Following that, on September 16th, I met with the principal, Ms. White, at my son's school, in which she informed me that there were statements from Camara classmates that they would be using against him in this hearing. The hearing was a recommendation for expulsion, and the terminology and literature used in the paperwork that was being handed to me for my son, it didn't sit right with me because I felt like he was a 4th grader, he was at home, he didn't do nothing wrong to, on my account. And I immediately, I wanted to get a second opinion or have some representation on my behalf because my conversations with the principal of the school, there wasn't going, there wasn't progressing at all. We seen things from 2 different views. I felt like she was acting robotically. I felt like the teacher, the behavior interventionist, they acted upon their part and did what they had to do according to their protocols, But I felt like somewhere in the system it should have been somebody able to make a judgmental decision on a case-by-case basis, according to these children, because we put people in charge of our children that have degrees and you're supposed to have, be able to make sound decisions, on a case-by-case basis or whatnot. But fast forward to the hearing or whatnot, I brought representation with me, Miss Chelsea, because I felt like her words would come across, different from mine, being that she actually studies law and, knows the right way to go about doing these things and whatnot. So, all in all, we here today that I got the whole world supporting my son. It's a humbling experience to be here, to even, for my son even be in a position like this. And I want to thank everybody, all you guys, the board members, Mr. Chairman. I'm trying to hold back tears because I'm so proud of my son. He don't understand the seriousness of what's going on right now, but he's making history, and I'm a proud father right now.
Well, and you very well should be. And I will tell you that, I, for one, am very, very thankful to you.
Right. And to clear things up, I didn't get the witness statements till the day before the hearing. I didn't get notice of the timing of the hearing and the proper timing. I received it in less than 24 hours prior to the hearing, and a lot of my amendment rights were, broken. My son's due process rights were broken. And come to find out, is more than just my son that's actually going through these things with these school systems and school boards and whatnot, and his children all over the world, that this bill being passed is going to help out in future families and children's ahead.
Sure, and that's what I was going to get to. We'll get to the legalities in a second. Good job, Ms. Cusimano. But as far as I want you to know, how thankful I am, and I think I'm speaking for every committee member here, that you've taken the time out of your busy schedule, that you have the nerve to come and do what you believe is right and what we believe is right. Because this is certainly something that I don't believe was anticipated by the school board, but should have been anticipated by the school board. And I know that this bill is going to address that. But if you wouldn't have taken the time and had the nerve to do this, who knows what would have happened. But I have to express that, because I can tell you that, this to me, as soon as I started hearing about it, you always want to get both sides of the story. And speaking to the Attorney General's office, exactly what you said is the case, that all the statements all backed up what Camara said. And if that's the case, then this is an injustice. And I appreciate you taking the time to come in and give us your testimony today very much. And Camara, same to you for doing the right thing. You guys are doing the right thing.
Tears of joy. I'm more nervous than he was.
Yeah, well, you said it. Sometimes knowing a little bit more about the system, it makes a bigger impact on you. So please stay up at the table with us for a few minutes. Ms. Cusimano, you want to add to the story?
Yes, Mr. Chairman. Thank you all for having us today. I am the representative of the Harrison family, and as Mr. Harrison testified, he had the wherewithal to call me, and we knew each other before, and say, Chelsea, this is what happened to my kid today. It doesn't feel right to me. Do you think it's right? And I jumped on it immediately and reached out to the school board and asked for all policies and procedures applicable to Camara's due process hearing as soon as I saw paperwork that indicated he possessed a weapon in violation of federal law on campus. The school board sent me the policies and procedures for the 2019 to 2021 school year. For parents and teachers. They also sent me an expulsion flow chart, which discussed due process for recommendations for expulsion. When I wrote back and indicated that there were no policies and procedures for virtual learning in place that would apply to Camara's place, it was basically told to me that I received all policies and procedures that applied to Camara. So I told Nyron that, let me jump on this hearing. Certainly this will get resolved. And this is just a paperwork issue. The hearing was an injustice in and of itself. As Mr. Harrison stated, when I had the wherewithal to ask for the personnel file the day before, or the student file the day before the hearing, that is when we found the student statements against Camara. We're talking 9-year-olds were asked to put pen to paper to say that they saw a weapon in the back screen of Camara while he was taking a test of his program. There was also a retaliatory statement prepared by the behavior interventionist after Mr. Harrison's meeting with Principal White that was not given to them. And additionally, we were not given board policies and procedures. We were only given policies and procedures for parents and students.
Just for the record, because you're mentioning all of these statements, if you could get copies to my staff
Absolutely.
to
I have
distribute to our
a
committee
full
members, I
packet
appreciate
that
it.
I can email from my phone to
Okay.
you all as soon as this is finished. So at the hearing, and for the first time, we learned that Louisiana Revised Statute 17416 was going to be applied to Camara's case, specifically 17416C, which talks about recommendations for expulsion, and later on in the statute, it talks about recommendations for expulsion for weapons on campus. And so throughout the hearing, I argued vehemently on behalf of Camara that his due process hadn't been followed, number one, and number two, that they indicated that he possessed a weapon prohibited under federal law and that this wasn't a school campus. Where were their policies and procedures to address virtual learning? They essentially shut me up, stopped me from talking, and informed me that Mr. Harrison's home was an extension of their government classroom and didn't let me speak any further. We went around and around for about 45 minutes about the various policies and procedures that are in place for Jefferson Parish school systems, and the hearing officer admitted that they didn't match Louisiana Revised Statute, and on 3 occasions informed us that we would have a right to appeal the decision, no matter if that appeal was an expulsion or something lesser than an expulsion. Immediately thereafter, the next day, we received notice that Camara was going to receive a 6-day suspension for a weapons violation and a social work assessment. I immediately wrote back that Camara's due process had been violated across the board. And I'm sorry, the day before I wrote the council and said a lot of due process violations occurred at the hearing. Can we discuss this? And she referred me to board policies on due process for the first time. Those board policies are different than the policies that they give to student and parents in preparation for these hearings. So now I'm working with a third set of policies, which also doesn't have a virtual learning policy in it. So the next day, around 10 a.m., we received notice that Camara was going to receive a 6-day suspension as well as a social work assessment. I immediately requested an appeal, and with less than 40 minutes of thought, Ms. Adams, Chief Legal Counsel of the Jefferson Parish School System, wrote me back and said that he has no right to an appeal. C-17-416. This is a suspension. It ends here. So for me, this statute is super important because a second level for hearing for offense that warrants a recommendation of an expulsion is necessary to protect due process rights of children in public education. As the Jefferson Parish School System currently applies the statute, it places the child and the family in a bureaucratic abyss with no way out and nowhere to turn. In Camara's case, unfortunately, we learned that due process was actually anything but due process. The Jefferson Parish School System wrote him up for a weapons on campus charge and put all over his paperwork, a 9-year-old's paperwork, possesses weapons prohibited under federal law. And then at the hearing, and then after the hearing, they came back and said, just kidding, we're changing the charge after the fact. It's still going to be an on-campus violation, but it's going to be for a facsimile weapon, and you're going to get 6-day suspension, and we're going to open your home to a social work referral.
But they didn't really say just kidding.
No, they just changed the charge.
Sure.
Due to my interpretation of the statute and a lengthy battle with Ms. Adams and several member emails, nights, 10 o'clock night, 11 night, to each member of the school board, including one that's an attorney. I read his bio. I read that he did this kind of work. I reached out to him. I said, get level with me, read this statute. If he's recommended for expulsion, he should have a second level review. It shouldn't end at the superintendent. Expulsions are egregious offenses. This shouldn't be like a one-stop shop at the superintendent's review. Ms. Adams wrote back on behalf of everyone indicating that I was wrong. Well, then Attorney General Jeff Landry saw the news. We came and met with Jeff Landry's office, and they interpreted the law as I saw it and issued an opinion. The next day, Mr. Harrison sent a letter back to the school board, to President Kuhn, saying, please, grant my son an appeal pursuant to my attorney's interpretation of the law as well as Attorney General Jeff Landry's interpretation of the law. The school board did not even write Mr. Harrison back. The school board's attorney, Ms. Adams, wrote me back and said, I've been asked to give you an explanation. You do not get an hearing for an expulsion. You you do not get a hearing for a suspension. You only get it for an expulsion. Well, their policies indicate that you get a hearing if it was a recommendation for an expulsion, but they're now interpreting the law to state differently. What this statute will do, it will clear up any confusion, and it will side with my interpretation, and it will allow children, in Camara's case, a second-level review for offenses that are as serious as this. The second piece of this is a massive policies and procedures gone awry case. I've never seen policies and procedures as inconsistent as those of the Jefferson Parish School Board. I've had the opportunity to see some of the other school boards' policies and procedures, and while there are always errors in policy and procedure, that's what lawyers are trained to pick apart. These are grossly, not only negligently written, but misapplied across the board. And I believe the portion of ordering school boards to sit down and put pen to paper before December 30th to write virtual learning policies to protect kids like Camara at home for situations that we haven't even thought about yet, such as a child having ADHD medication in the background that's their siblings. Is that a drugs on campus charge? Things that could occur in the home that aren't on campus. There needs to be something in place to protect these children, because as it stands, there's nothing. And despite battling with them and pleading with them, there was nothing that we could do other than file suit within 10 days. And on last Friday, we filed suit for multiple violations of federal and procedural due process, as well as requesting a court to evaluate 17416. And on Monday, we filed a restraining order on the social work assessment, which was granted in the 24th JDC yesterday in favor of the Harrison family. We very much appreciate your time. I cannot reiterate the importance of this statute. I will say one thing I do have permission to say, that by taking this to the press and by the Harrison family deciding to be the face of change, my law firm has not stopped ringing. I live next door. It's a double shotgun in New Orleans. It rings from midnight to 6 a.m. every time this news story airs, and it's someone in this state or in this country that has a similar case of something that was seen in the background and their child facing discipline for an unwritten policy or procedure. If you guys pass this, we will be the first state in the United States to recognize this issue, and we will be the first state to create policy and procedure to protect virtual learning students, and it would be awesome. Thank you for your time today, and I really look forward to hopefully seeing you guys in the Senate and then on the floor.
Oh, and thank you again, as I have with the Harrisons. Thank you for taking this on. I mean, I think it's fortuitous that you happen to be friends with Mr. Harrison.
Absolutely. It was a happenstance that he had the wherewithal to call me. Not many families would have that opportunity to have a lawyer on speed dial. And the other thing is, one thing that I really want to stress is that when the Jefferson Parish School Board started this year, they just issued an attendance policy, is what I'm hearing. They didn't tell parents, this is what your virtual classroom should look like. They didn't say, set this up, make sure this isn't in the background. And how many parents in a school system and with 5 children in a 3-bedroom home can afford to conform their home into government conforming classrooms? It's just not possible, and we need to protect these children. And Camara is the face of that change.
Absolutely, and I think this bill goes a long way to providing those protections, which is exactly why we have to do this. And I don't think we're going to have any objections here, but I do have one red card from somebody who wants to come and testify.
Thank you, Chairman.
But if you would do me a favor, I'm assuming that your petition that you've already filed has a chronology of the events that occurred.
The petition has the chronology of events as well as the policy procedures, as well as the TRO and petition for a preliminary and permanent injunction.
Forward a copy of that as well to my staff, just so that we can look at it and see if there's anything else that we have to take into consideration with the way that these issues are being handled. I mean, as from a policy perspective at the state level, if we have to take action to make sure that we're being fair to our students, then we want to be proactive with that to the extent
Whoever
we can.
is opposing this bill, I'll step out in the hall and send you the petition right now.
Well, no, just whenever you get a chance. That would be fine. I can't read it today anyway. We have a little hurricane, a little friend out in the Gulf that I have to get home and help my community with. But no, thank you as well for coming today. We have several other. Oh, wait, we have some questions for some members before I let you guys get up from the table, if you don't mind. Representative Phelps, you have some questions?
No, sir, just to comment, your last statement of the phone calls and what's going on in the no guidelines, I just wanted to say to my committee members that has been my sentiment exactly of now really what was going on when there was no strict guidelines from the state of how the district should apply across the board. That was definitely the thing that went across the state. It wasn't just in Jefferson. Parents not knowing what to do, when to log on, how to log on. The districts were not informed and did not know enough, because they're always doing everything on their own, of how to get guidelines out, because that was one of the things that was not a basic mandate on how things should look. But thank you for reiterating that, and hopefully this is a lesson for us.
Certainly the Attorney General.
Can you get to the mic for us, Ms. Cusimano? Ms. Cusimano, can you get to the mic for us, please? So,
One thing I do want to address on that is, yes, the Attorney General opinion letter in support was sent to Bessie as well as all of the superintendents. So we are trying to address this at more than just the board level from the state.
And I'm just
Thank
a
you.
proponent. At some point, the state should be the leader and the guider for our districts. They do a lot on their own, but at some point, something like this is where they should step up and be the leader. But thank
Hopefully
you.
that's today.
well, and just from a constitutional standpoint, just for the record, constitutionally, the districts have a lot of autonomy, and the state can't just come in and order them to do something. But certainly with setting guidelines like this, I believe it's appropriate, and at some point we may want Bessie to look into this. But as policymakers for the state of Louisiana, I think we're doing our job today in asking each district to take their discipline committees and look at this issue. So we're taking the right first step. Now, just make sure.
But the guidelines that we asked to set for this COVID, the guidelines that I expected to hear when Bessie sat here, my position is it could have been more, it could have been better, and this is an example of what should have gone down.
I understand,
That's
but
just my opinion.
we still have to deal with the
That's just my
constitutional issue,
opinion.
Representative Phelps.
I get you.
Representative
Violated at all.
Edmonds for a question.
Thank you, Mr. Chairman. What a horrific story, but how encouraged we all are today. Camara, I had only one thing that I had a little conflict with, and that is, don't you like Zion Williamson? I mean, love basketball. You got to love Zion, huh?
I'm sorry, Ryan.
Yeah, but he's not my favorite player.
Okay, all right. Fair enough. Fair enough. I wanted to say, we can't help it. I mean, when we get these true life stories, I wanted to say to Camara, first of all, the truth will always set you free. And I'm so proud of your bravery and telling the truth to your parents and to your teachers, and you stand on the truth. Every man and woman that's sitting at this table, I can't answer and speak for them on every issue, but I promise you, every one of these people that you're sitting in front of today, Camara, are going to fight for you. I know these people. I know how they feel. I don't have to ask. I know them. And so every one of these people are your friends, trying to make this thing be right in the long run. So I'm glad you're here, and we're grateful for that. Mr. Harrison, I'm a father of 4 sons, had a child falsely accused as a middle school student, and I am for supporting teachers, principals. I'm 100% for authority, all of those things. But every now and then, it takes a father to stand up and say, nope. And that's what you've done. And, I'm from one father to the other. We're proud of you as well. Thankful for what you're doing to stand up for your son. That's what your ultimate responsibility under God is, you're the man, and God has given you that. Thank you for doing that. I did have one question that I want to make certain that we're very clear about, because I think we're all grasping this story. I commit to this, to fight for your son, whatever, no matter what the result of the bill is, up or down. I think you're going to find great support today. But I want to make certain, just of a clarity of an issue. This was a Daisy BB gun. Is that not correct?
Yes, sir. Thank you for your support. And yes, sir, it was a Daisy BB gun, the rifle kind.
Tell them why you bought it and where you bought it.
I bought it from Walmart for Kamara's last birthday that just passed, June 14th, 2020. 2020. Kamara's 9 years old now, June 14th, 2020.
Yeah. So again, I know we're not getting into the content of the bill yet, and I know that Representative Romero is going to come back to the table of issues that we might have with content and how we get this right. But I'm I'm sorry for that, that this thing has happened for you, but I got to believe some kind of way good has and is coming out for you and your family. And I do pledge my support and to try to help you, not only as a legislator, but just as it's just doing the right thing is always the right thing.
Yes,
And again, I can't help it but to speak to you today. I appreciate a dad with tears because I'm a dad with tears. Again, I have 4 sons. They're all 4 of my favorites. And I know I see that in your eyes today. And be encouraged that you have friends that you don't know that's been placed in your path today, that together we'll get this right.
Yes, sir. Yes, sir.
Thank you, Mr. Chairman.
Representative Carter for a question.
Thank you, Mr. Chairman. Thank you, Mr. Harrison, for your good work. I'm born and raised in Algiers myself, and I'm up here, So thank you for being a good father, for being a good citizen, and I want to thank you for listening to your son. And we're all listening to both of you and your lawyer today. But you standing up for your son and standing up for your son's rights protects my sons. I have 2 of them. And I have the same concerns that you have. So thank you so much for standing up, for asserting your rights, and for demanding change. And thank you, Attorney Cusimano. It's good to see an attorney fighting for the good cause and doing what's right. And I'm a firm believer that when lawyers do good, their firms overflow with blessings. And it sounds like you're getting those calls.
Well, I thought this was going to be a 2-hour done deal. They thought they were going to get rid of this. I never did I think we would be before the legislature, but man, am I happy we're here. We got to stop this, cut it off at the head.
And
thank you.
No, thank you. And thank you, Camari. Keep up the good work. Thanks, Mr. Chairman.
Thank you, Mr. Carter.
Thank you, Representative Carter. Representative Amadi for a question.
Thank you, Mr. Chair. Over here.
Come on.
Good morning, and thank y'all for being here. This is just dramatic. And they often say that Louisiana's at the top of a lot of wrong lists, but I'm determined that we're going to get this right, so we'll be at the top of a very good list. And you just get to be the stars of the show while we do it all. Sometimes things happen unexpectedly. Mr. Harrison, I want to echo what my colleagues have said. Thank you for being not just a father, but a daddy. Thank you for stepping up. Many times parents are just very busy in their lives. I'm sure you have to work for a living full time. And often, whatever goes on at school, the parents just say, well, the school is handling it and I back the school, without really looking into the matter. And in this case, you not only looked into it, you've taken the lead in setting things right. I am proud that there's a daddy right here who actually bought a BB gun for his 9-year-old son. I think that makes Louisiana look good because this is South Louisiana. Actually, I think our whole state is known for having more than the average number of guns. And sportsman's paradise, it means something to me. Part of my heritage, and I appreciate you. I don't know if you've taken your son out to use the BB gun, and you don't have to say, but just the fact that you bought one means that there's something there that you want to pursue also, and I appreciate that. I think that the whole situation here, as I see it, let me ask you this. Have you ever been to the state capitol before today?
Once with Miss Cusimano.
Well, when we came to meet the Attorney General was the first time the Harrison family had been.
Okay,
So-
but you hadn't been before the legislature.
No, ma'am.
Okay, well, our committee meetings are public for a reason, and we like having the public come and speak to us, especially when their story is so critical for us to know certain details so that we can pass bills or not pass bills as needed. So I appreciate you taking the time and coming. I know it takes courage. Studies have been done where they've surveyed people, and they say that public speaking is a fear above death. And here you are, and you've succeeded. You've publicly spoken.
We'll
You
be
did
back
very
next
well.
week.
Well, very good. You can get really good at this. Camari, I appreciate you for coming today and for speaking and having the courage to join us here today. Just so you'll know, don't tell anybody, it's a secret, but when children sit at the mic, we all listen a lot better. Okay? Nobody heard that, right? So we're paying attention to every word you have to say because it's unusual that young people come and speak to us and we want to encourage you. We're elected officials. We're supposed to be representing you, and we don't read minds, so we do that best when we hear from you. So would you let me know that you're going to continue to talk to legislators in the future so that we can do our job well?
I promise.
Thank you, sir. That's wonderful. And I don't know your family background, but if you have not already looked into this really awesome book that tells a story of David and Goliath, I think that's appropriate here. Sounds familiar to you? You know that story? Well, I see you as a David, and I see your dad as a David, and I'm very proud of y'all, because the Goliath that you're facing is one that I have faced for many, many years myself. My family comes from a homeschool background, and I don't know that there's ever been a case in Louisiana, according to home being a house first. It's your home first before it's a school. But in many other states, there have been cases, and I believe that as we go through the process of resolving your issues, that we need to set a precedent, maybe even in Louisiana law, spelling it out, that your home is a home first, and it's a school second, even in the case of virtual schooling, and I believe that'll resolve a lot of this. Thank you all for your time today. I look forward to good things for y'all in the future.
Yes, ma'am.
Thank you, Mr. Chair.
Great job, Representative Amity. Representative Hilferty for a question.
Thank you, Mr. Chair. I do have some questions for the bill's author, so if you'd like me to hold, but thank you both for coming here. Thank you, Mr. Harrison. I know it can be scary. And Camara, hey. You did a great job. You really did. It's scary to sit in that chair, and you did better than most people do. So good job. We're proud of you. And like Representative Amity said, keep in touch with us and encourage your friends and your classmates to do the same. You can call us or you can email us. We love talking to students. Thank you both.
Representative Owen for a question.
Thank you, Mr. Chairman. Thank you all so much for being here. I really, really appreciate your time. Thank you, Counselor. I don't really have a question. I just have a statement for both my colleagues and for those who are listening. I have been accused often of giving people the benefit of the doubt too often, and because we're in this middle of this COVID thing, it's all new territory for everybody, and people are generally doing the best they can, but this doesn't feel like that to me. There's a term called soft tyranny that's out there, where people will stick their nose and try to control people's lives beyond that which is prescribed or expected, and that's what this feels like. I hope it's wrong. I hope these are honest mistakes that have been made, but this feels like tyranny to me. And the whole issue of the social worker and all the other stuff and the denial of rights, this has to be confronted. And I'll be proud to sign any legislation that comes here to let us confront what I think is this soft tyranny, which could grow into something else, and it's got to stop. Thank you all for your courage.
Thank you.
Thank you, Mr. Owen.
Representative Bress for a question.
Thank you, Mr. Chairman. I guess this is really heartwarming, and I guess I can personalize it. As a young African-American male, I've been stereotyped for the wrong reasons. So I would just like to commend Mr. Harrison and Camara on you guys being brave, for your courage, and commend you for being steadfast. A lot of times I know I've seen situations where dads and parents have given up or just went along with the system and ultimately took what the system told them they had to do. But you guys, I commend you for coming here, taking a stand, and fighting for what you guys know what is right. To Mr. Camara, you are our hero today. And I want you to utilize this or see this as an example to yourself as you move on throughout your life, throughout your school days, go to college, and become a productive young black man in today's world, that you can change the world. This legislation, once it's passed and signed by the governor, will not only impact yourself, it will not only impact students across the state of Louisiana, but ultimately it will impact black kids, all kids throughout the state, throughout the United States of America. So I commend you. I ask you to stay fast, keep doing what you're doing in your schoolwork, and to be a leader at whatever you do. Daddy, keep doing what you're doing, brother. Keep doing what you're doing. Thank you, Mr. Chairman.
And I think we have two leaders sitting at the table right in front of us. Representative Phelps for a question. No? Representative Freiberg for a question.
Thank you, Mr. Chair. Camara, I thank you and your family and your attorney for being the spark that sort of lit the fire for us to look at this. And Rep. Romero, I appreciate your bringing this to us. As a school board member, I sat through suspension hearings, and I know it's very difficult on school systems who have established laws and established policies not to adhere to their policies. So I think we're here today because we're looking at policies for virtual learning, which I think are very, very important. So I understand that difficulty that school systems have, and I think this was rather egregious, but I understand perhaps where they were coming from too, because they have policy and they thought they were doing the right thing. But by establishing some virtual policy, which is what you are trying to do here, and you were the impetus for, I think we're all going to be better off, not only parents and students, but school systems, because they'll know what their policies are. And that gives us all guidance that we need. So I appreciate the sacrifice y'all have made to be here, and I appreciate your bringing this bill. And I don't know if anyone's move to approve, but I would move if appropriate.
I was going to do that because my name's on the bill already, but we'll address that when we get there. Representative Hilford for another question.
My question is for the author of the bill, so if you'd like to wait.
He'll be coming back to the table in just a few minutes.
Okay.
Representative Jefferson for a question.
Thank you, Mr. Chairman. Mr. Harrison, Mauri, thank you all so much for being here. Often, Dr. Owens mentioned something about tyranny, and we've heard a lot about that. And as I heard your story and I've heard you today, the first thing that came to my mind was common sense. You know, I often query, since we've come here to this special session, I said, why are we here? You know, and today I see why we're here. To be, those are the recipients of what you've given. And I want to say to you, Mr. Harrison, thank you for being an example, because we can, as policymakers, we can legislate, we can do various things, but what you did is nothing that we can do that would ignite what you did. When you got that call, you immediately, and the good thing about all that's transpiring today is that your son's children will be able to look back and see the day that you all shook up the state capitol. So I'm excited, and I do also understand the challenges that many school boards have. This is uncharted territory. And so what you're doing is not only going to affect, you all, but them as well. And every now and then you have to take a good look at where we are. And hopefully this will be that shot that will insist that all of us, our rights are protected. And your son did an outstanding job. And the only thing I would take, is that they kept saying that you all are the face. He's the face of change. I would say that he is the handsome and articulate face to change. He did an outstanding job. So thank you for what you're doing. Continue the good fight. And continue, as the late Representative John Lewis indicated, continue to make some good trouble. Thank you.
Thank you. Jefferson.
Good job, Representative Jefferson. Representative Freiberg for a question.
That was an accident.
Okay. Representative Phelps for a question.
And I'm sorry, this very quick, Chairman. Mr. Rep. Edmonds, I'm going to try this one more time. Camara, who's your favorite football team?
I don't know that much about football.
Okay, what about this? Have you heard the name Drew Brees? The New Orleans Saints?
Oh, yeah, the Saints.
Yeah, that's our team. Yeah.
Representative Thomas for a question.
Thank you, Mr. Chair. I'm over here.
Come on.
I think there have been a lot of awesome things said today about the young man, about the family, about how they conduct themselves. Kamari, I'm over here. I love it that you like math. that's your favorite subject, and I would encourage you to keep liking it and keep learning more and more and more about it. And Mr. Chairman, I would like to, I think we see how this is going, and I think I would like to ask that the author consider naming this, once it is passed, the Camara-Harrison bill. Act.
That's great. I can tell you Representative Amedee already working on that. So
Okay.
not to steal your thunder there, Representative Thomas.
We've
but,
been calling it that in the news,
yeah,
Kamari's bill. So thank you so much. That means the world
think-
to Mr.
Thank you, Ms.
Harrison.
Thomas.
We'll definitely be able to do that. You good, Rep. Thomas?
That's it.
Okay. Representative Jefferson for another bite?
No, I'm good.
Okay. Representative Freeman for a question.
Well, not a question, just a comment, and I just want to thank you both for being here. I'm a mom of 4 kids, and I love that you love math. I echo Representative Thomas because I always push my kids toward math. 2 of them really love it. Some of them don't so much, but that's okay. And one of them's studying to be a teacher, and she's working to teach kids like you here at LSU. So I just thank you for your courage and for being here. And I've been very emotional listening to everybody's testimony as just a mom, because I know how hard it is, Mr. Harris, to fight sometimes for your kids and the things you have to do and the wrongs that come. And it brings back a lot of memories as a mom, and my husband and I, certain times where we'd have to go to the school and intervene. So I appreciate you doing this and being a leader, both of you. Thank you so much. And keep up the math.
And Mr. Harrison, I wanted to tell you before, you never have to apologize for getting emotional around here. In fact, I will tell you that getting emotional sometimes wins the day. So thank you, for everything you've done. I think that was the last question. Members, any more questions for the Harrisons? Okay.
Thank you for your time. Thank you, Mr. Chairman, members of the board.
Okay, so if we could get Representative Romero and our Solicitor General, Liz Murrell from the Attorney General's office to the table so we can take a couple of questions on the bill and maybe propose an amendment. And if you'd introduce yourself for the record, our Solicitor General, please.
Thank you, Mr. Chairman and members of the committee. It's so exciting to be here today. I'm so excited that we've been able to be part of helping to draft this bill and kind of try and find a way to strike the right balance. I would like to recognize, because I know we're running short on time, Mr. Tim Brown, who is also here. He's another parent who has experienced the almost exact same problem. And in that situation, it was also in Jefferson Parish, but we've seen I know of other situations that occurred in some other parishes, and so we know this is not an isolated incident. The clear problem that occurred across the board is a lack of compliance with existing law, which is Louisiana Revised Statute 416.8, Title 17, 416.8, which says that there's a disciplinary policy review committee that's supposed to meet annually and review policies and update them and provide notice to parents and children, and to have a meeting within the first week of school. And that's what this bill does. It tells school boards to go back and make sure that they've done that. That didn't happen. I don't think it's happened in any school board across the state. I could be wrong about that, but from what we've been able to tell, this all has sort of hit everybody so quick and so fast that that they've been scrambling to deal with a lot of things, and this kind of fell by the wayside. But that the people who suffer from the grown-ups' failure to address a situation that needed to be addressed should not be our children. And I have 4 sons too, and I think that, when you see this happening and you know that it's wrong, and you expect grown-ups to stand up and be grown-ups and take responsibility for failing to having established proper policy and given people the notice that they deserve. This is not hard. It's not hard to fix the problem, and it's not hard to wipe out the consequences that have occurred for children who have already the ones we don't even know about, and the parents who don't have lawyers and shouldn't have to go and fight to get their child's record cleared for something that was clearly a failure of grown-ups in the room to do what should have been done. So I think all this bill really does is say school boards go back and follow the law, notify parents and children what the rules are so they can follow those rules. And I think we recognize that there can be situations that can be serious, and that there needs to be a balance struck, and that schools need to there's got to be a cool, thoughtful conversation about what the policy should be, and not just a reflexive application of laws that were never ever written for this purpose, to situations that everybody uniformly thought was just not the right thing. So I'm glad to be here today and to work with you on the language of the bill if you have concerns or to answer questions. But honestly, I think the basic purpose of the bill right now is to clear the record for kids that were treated improperly in the system because these laws weren't written for this, to send the school boards back to work on policy and to follow the law, and not to dictate necessarily exactly what that policy is going to be, but to recognize that we're in the home and that we need to be careful about and thoughtful about how we write those policies when they are applying to the home, and we need to be thinking about giving people a hearing when their kids have been recommended for expulsion, particularly on gun charges, which trigger, I mean, if you haven't read those statutes to see what they trigger automatic suspension, automatic expulsion. And so, there's not a lot of breathing room there for school officials. And I think, we should examine that. But at least in this context, we're talking about these kids uniformly, they were in their bedrooms. They were on school, and, my kids have tried doing virtual school at home, and it is challenging. It's challenging for teachers and schools to deliver it. It's challenging for families to make sure their kids are being taught and acquiring the learning. But this was not something that I think anybody expected, and the uniform response has been, he's at home. Mr. Brown had the exact same reaction when his child was recommended for expulsion for a Daisy BB gun being seen on the screen, and he was like, he's at home. He's in his bedroom. Nobody told me. And so when you start hearing that over and over again, that's a failure at the policy level.
Sure, and let me thank you again, Ms. Murrell, for you and Attorney General Landry stepping up and taking this issue on, because it's definitely something that has to be addressed. Obviously, we're in a position right now where we have an unprecedented pandemic that we're dealing with, and with all the new virtual learning, I can understand why there were some glitches, but you guys stepped up, and we're addressing those glitches now, and hopefully we'll set a standard that other states will follow. Getting to the bill, I just want to make sure I fully understand it. I think I do, or that the public fully understands it. It's enacting an expulsion appeals process, correct? Even if that expulsion is reduced to a suspension, as it was in this case. It gives you 5 days to appeal to the school board. It gives you 10 days to appeal to district court. Is that your understanding?
Just to be clear, Mr. Chairman, that is already what existing law provides. Our interpretation of the law is that upon recommendation for an expulsion, these rights attach. That's
these rights
a clear statement of existing law, but there's been the board took the position that if they changed it on the back end to a suspension, that they only had that it ended there and there was no appeal from the superintendent's decision. We don't read the law that way. That is why we sent a letter out to all the school superintendents and to Bessie on Monday of last week, because the law says upon recommendation for an expulsion. It doesn't say upon expulsion. And, this is about due process rights. They attach when this law gives them the rights, that's when they attach. And they attached upon recommendation, not upon expulsion. So we wrote the law. We need to apply the law. If we don't like the law, you can change the law. But we can't take those rights away on the back end after we initiate the process and then say, sorry, we're going to pull the rug out from under you, even though what the law says is upon recommendation for expulsion, you get these hearings. So that is existing law. It's just clarifying existing law.
And we're clarifying that it'll apply to a situation such as this.
Correct.
All right. And it gives you 5 days to appeal to the school board or 10 days to appeal to district court.
Existing law.
And I had mentioned to you that I had a little concern about the definition on page 2, line 15, where you're defining virtual instruction, and you had said that we're defining it as occurring from school property. I was concerned about a situation where a teacher may be at home conducting a virtual class, and you said you didn't have a problem with redefining that. Would you work with me between here and the floor to come up with a better definition for that?
Absolutely, and I think we tried to say including but not limited to. So we can.
Right,
I'm
but I
happy
think
to
I
work
dropped
with
the
you
ball, and I didn't request an amendment. So I don't want to belabor the committee's time right now. So if we could work between here and the floor, and I'll make that clear. And then we're also getting into attorney's fees, and in reading the page 3. Starting at line 8, it looks like the bar is very, very high to request attorney's fees. But we are allowing attorney's fees in the case such as loser pays. Is that where we're going with this?
It's not strictly loser pays. I mean, I think the attorney fee provision is only intended really to apply generally if there's been a bad faith action or egregious action where our position has been pretty clear. We think that it was that the school knew at the very beginning that this was a BB gun. I cannot for the life of me understand a recommendation for expulsion for possession of a federally banned weapon. I mean, I don't even know what that means. But I don't understand it when the school knew that the child had a BB gun. So this is a situation we want to be mindful of not letting bad facts make bad law. But I don't think it is bad law. The teachers do and the schools do get attorney's fees if there's a bad faith. And so this is the families don't, and it becomes very difficult sometimes for them to write something that's wrong if they cannot get a lawyer to do it. And so I think that in a situation where there is a sufficient grounds to show that there was a gross failure or malicious or vindictive conduct, then attorney's fees certainly are proper, and they shouldn't have to file a civil rights action to get them.
I'm not arguing with you. I just want to, for the record, make sure that the public understands where we're going with this.
I can make one statement on that.
Well, I want to read for the record that the charge has to be knowingly false, which is a very, very high bar for to award attorney's fees. But again, I think that that's appropriate. Ms. Cusimano?
I'm okay.
You good? Okay. All right. I think that's all.
Is it no or should
it says knowingly. It's page 3, line 13, or initiated a charge that is knowingly false.
Consider between here and the floor adding or should have.
Well, I'll leave that up to you, Representative Carter. All right, Representative Thomas for a question.
Thank you, Mr. Chairman. I have a question about a vocabulary word, please. As I was doing my homework and reading the bill, at the top of page 3, actually it's line 1, the term used is de novo judicial review, and I looked the word up and it means afresh, again, anew, and I would like for you to expand on that, please, what that means.
Thank you, Representative Thomas. It is a term of art in the legal world. So judges will know that term is in there because judges know what it means to give de novo review. It means we start anew. You get to look at the whole record, and you're not bound or restricted by the decisions that were made below. So it has legal significance in the law, especially when it gets to in front of a judge.
I figured that that lawyers and judges would know what that means, which is why I headed to Merriam-Webster. Thank you, Mr. Chair.
Okay, Representative Thomas. Representative Amity for a question.
I just had my light on, sir, to get back to that amendment at the appropriate time.
Okay. Representative Hilferty for a question.
Thank you, Mr. Chair. I do have are we creating a separate due process for virtual school? Because it does on page 2, it does reference, line 23, but 22 starts that process. Any student who's been subjected to suspension or recommendation for expulsion for behavior display while participating in virtual instruction, is this due process different from if you were in school?
No, Representative Hilferty. The amendments with regard to the hearing clarify existing law with any recommendation for expulsion.
But this says
the specific virtual school material is intended to retroactively wipe out the charges related to virtual school events dating back to the beginning of COVID, because policies have not been properly enacted to cover that situation, and to ask school boards to go back and follow the law and enact those policies. And until that time, they shouldn't be making those recommendations. So
I understand the intent, but what I want to look at is the bill, because this will apply, obviously, moving forward. And here, as I'm reading it, and that's what I want to understand if I'm reading it correctly, under Section 2, line 22, page 2, any student who has been subjected to suspension, and then it says specifically while participating in virtual instruction, and then it lines out A, B, C, D, A, B, and C, and D. Are those A through D, are those different from the in-person process, or is this a separate process for virtual instruction?
Can you tell me again exactly what lines you're reading?
Okay, bottom of page 2, line 22.
Line 22, okay. Any student who has been subjected to suspension or recommended for suspension for behavior displayed while participating in virtual inspection shall be entitled to the following. Yeah, I think the section, so the retroactivity language was placed in Section 2 on page 3. I think that
Okay,
what we
what line are
was
you on?
to
I'm sorry.
clarify the law so
18 on page 3.
Okay.
we intended to clarify the law that any child who's been recommended for expulsion has a right to appeal to the school board and to the district court. And that was simply a clarification of the law that will apply to everything. It's not limited to
So
virtual
what you're
instruction.
stating in
particular
sections A through D is existing law, but adding the virtual component to it?
I'm going to have to go back and look at. I'm not exactly sure what.
Because as I read
I'm not
it,
following your question the way you read it. I want to kind of look at it again. I'm happy to work with you between here and the floor to clarify it if you think it's creating a separate process. Our intent was to create a procedure right now for those kids who had been disciplined previously, and then to make sure that the law was clear going forward that you have a right to a hearing if you've been recommended for expulsion.
To me, it would seem it should apply. We should have a similar process for students that are physically in school. Different, obviously, virtual school is different. Like somebody said, you have your medication on your desk and it's your sibling's medication or something. That's different in how we treat the virtual schoolroom. But the due process piece of it would seem to be similar, and that's what the confusion I'm having.
I understand.
Are we creating a new process for the virtual side? And if that process is better, should it apply to the in-school side? You see where I'm going?
I understand. I see where you're going. I think that section that you're reading was actually intended to apply to the kids who had already been disciplined starting in March 13th to now, when the school boards had not necessarily complied with existing law to have a disciplinary policy review committee review their policies and give notice to families. So it's setting up a process to give them a mechanism to go back and have their cases reviewed. I hear what you're saying.
That's
is
not
maybe
clear
we should
in this
look
bill.
at.
I don't
so we'll
think.
clarify that.
Okay.
And make sure that that's clear.
Sure,
I think it's because the retroactivity language got put into Section 2.
Yes.
And so if we build it back into that other section, it should clarify that. And I'm happy to work on that.
And I do have another question, because we talked about attorney's fees briefly. It seems on page 3, line 6, I see attorney's fees mentioned twice. If you can just clear that up for me. So the attorney's fees are awarded to the student, parent, guardian, or tutor to clear students' records, and then it's again mentioned in section L, and I wasn't sure how those two
So one was intended to apply to the people who have to go back since March 13th and clear their child's records, and one was intended to just change the law and allow for attorney's fees when there has been a knowingly false charge or a grossly sort of negligent
But the way the attorney's fees are handled, as I read it, in those two sections seems to be different. So if it would seem that the attorney's fees would be handled the same, whether in the retroactive version as well as the forward version.
Well, I think the intent for those people who need to go back and clear their records is that they should be able to get an attorney to help them do that. There shouldn't be a restriction on their ability to get attorney's fees. They should be able to go get an attorney that can help them clear their child's record in that span of time.
Okay.
The permanent provision is a higher standard. It is not just attorney's fees all the time, but I mean it's just more of a higher standard that a judge can award them if at the end the judge finds that there's been improper conduct.
So this is probably more than there's probably more to this than an amendment that can be handled in committee. So it probably will need to be worked out between.
And I was going to ask you if we could wait and do this, but get your issues on the record.
Well,
I will definitely bring an amendment.
Understand where?
Yes.
It's this section 2 on page 2 that needs to be looked at, and that's all I'm asking is that we just look to clarify that, because that was some confusion I had while reading it.
It's a good point.
Sure,
I appreciate you guys bringing this, and thanks for your work on it.
Representative Romero, you will, for the record, you will definitely accept an amendment to handle those issues, correct?
Certainly.
To clarify those issues.
Yes.
Okay, and I will work on it as well, Representative Hilfer. Thanks for bringing those up. Representative Jefferson for a question.
Thank you, Mr. Chairman. I guess kind of in line with Representative Hilferty regarding the first question is, we do understand we're expanding as it relates to virtual or online. That's correct?
That's correct.
And in many instances, as the chair was summing up, for the general public, what's going on with this bill, you continued on many instances, that's existing law. That's existing law. So my question, and I guess I get it regarding the retroactivity. Do you think it might have been appropriate to maybe do a writ of mandamus, to compel these school boards to do what's already existing law, not the online, but what's already in law, and maybe through acquiescence, just time, they haven't done it. You think that?
And Representative Jefferson, I will tell you that, Ms. Cusimano has filed a writ of mandamus in that case.
Okay.
But your bill is essentially, effectively going to create one. It's telling the school boards, go back and follow the law. Look at your policies. We're not telling them exactly what policies to write at this point. I mean, what we think is there needs to be some cool thought and common sense, some thoughtful reflection about what the policy should be, taking into account the location where some of this is occurring. And there are going to be some constitutional concerns. That does require some thoughtful discussion. And I think that, smart people who have the interest of protecting the schools, the children, and the learning environment and the home can come up with rational policies that will survive constitutional scrutiny. But I think that, your law is that mandamus. It's telling them to go back and do this.
I led you right into where I was trying to go. So yes, it is invariably a writ of mandamus with the addition to the online.
Correct.
Okay.
It's saying go back and look at all your disciplinary policies right now and update them, and that should include virtual. I mean, they're already supposed to do this annually.
Yes, ma'am.
And frankly, I got that information, I should have been able to just read the law and see it myself, but I had not. It was the school board attorney who brought it to my attention.
Okay.
So
Secondly,
I was a former school board attorney.
Being retroactive. What do we do for those individuals, and I'm sure we don't have a number, who perhaps have gone through and have been, expelled since, March 13. Are you looking only for attorney fees or what have you? What do we do for those kids who went through the system and, through no fault of their own, if you will, they've been affected in a negative way?
Well, and that is the reason why we listed some of these items, that any student who's been subjected to suspension or recommended for expulsion is entitled to a hearing within 30 days before the school board. I think the school boards have the ability to give some relief to these families. I think there is, I don't know what every situation is. There was no way for us to know. Children have privacy rights. These families have come forward and basically, spoken publicly about their children's situations, but we don't know what every situation is, and we want to respect their rights to privacy, but give them a chance to go back. Most of the school boards, I think, are going to be open to doing the right thing for kids. If these kids have been put in alternative schools, and I had one of those cases, honestly. I spoke to a parent, and that child had been virtually the same situation, had been expelled, and was about to be, having to start in an alternative school. And, these are life-altering consequences for a child, and I don't know how many of them may have been removed to an alternative school. I think that the school boards are ultimately going to have to grapple with situations where that may have happened, and there may be some irreparable harm that was caused to a child or his family. There are still ways they can address that. They can provide tutoring. They can put the child back in his former school. They can give counseling and support. I think there's a lot of ways you can fix this, and if smart people who care about kids and are going to come to the table and try and do the right thing.
And exercise a little common sense.
Exercise a little common sense.
Because that's my other point. And
Rep. Jefferson, it was my intention, and I think our intention, to be able to allow those students, and I think there's been a number of them, to have the opportunity to go back and expunge their record or to get back into a normal routine, right? Whether it's in normal school or virtual or whatever it is, and that was what we were trying to do, and to give them the opportunity, the same opportunity that Camara or anybody else would have going forward.
Very good, and that's my point. And then the sections we've talked about briefly regarding the award of attorney's fees, and this is just would you be amenable to reasonable attorney fees? And what I mean by that is what I may charge is probably going to be totally different what my colleague, Representative Carter, may charge. So I've seen in many instances...
Higher or lower? Higher or lower?
I'm sure his will be much higher. But just reasonable attorney fees, because, again, he may be billing at $7.50 an hour, and I may be at $6.99. So let's look at the reasonable aspect. Would you be amenable?
That makes perfectly good sense.
I can't afford either one of you guys. Jesus.
And Representative Jefferson, to your earlier point, I would also like to, I don't know if everybody knows this, but I didn't, and so I would share that the consequences are not just potentially alternative school. There are mandatory referrals for firearm charges to the district attorney.
Okay.
That happened in a case. This child was referred to the juvenile justice system for a BB gun being visible on the camera at home, and now that child was expelled and sent into juvenile court. These are long-term consequences. The gun charge stays on the record and gets reported up to other schools where the child applies, and so that school can then decide whether to take the child or not take the child. And the details get lost to history. What stays is what's written on that piece of paper, and what was written on Camara's piece of paper was possession of a federally banned weapon. And some of the others say other things about bringing a firearm to school. Well, it's not a firearm, for one thing. They didn't bring it to school. They were sitting in their bedrooms in bed on a computer laptop. And I think we just have to remember that these have long-term consequences for the families and for the children. And we have built these laws because of terrible, terrible things that have happened at school. And so we don't want to lose sight of that either. But we've got to exercise some common sense here, and those are the things that an attorney's going to have to come back in and clear, not just the school board thing, but they've got to go and visit with the district attorney or go to the juvenile court system. And so it can be pretty complicated once this thing starts working its way through a system and they get stuck. We agree it's a bureaucratic, black hole for some of these families, and if you refer them to social services, now they're in the social service system, and that's sometimes difficult too. So it just builds on itself, and it is an albatross around the kid's neck and around the parent's neck, and it never should have happened in a lot of these cases, or cooler minds should have come in and fixed it without them having to be in the situation that they're in now.
And then lastly, I know the answer, but do we need to include charter schools as well? But we know they are public schools, just for clarity, or Mr. Chairman?
You know, I did, the law I think excludes charter schools, and I would defer to some of the folks on this committee who have more experience with dealing with charter school policy. We did not include it because I think the law now excludes charter schools and lets them write their own policies. But to the extent that they are public schools and they are already bound by the law and our procedures that are set forward for ordinary public schools, then I think the same reasoning applies. I see no reason not to at least give them a hearing,
right,
and not at least kind of make sure that the records are expunged for children where there's been no virtual policies actually revised and no notice given to parents. I mean, that the parents uniformly are saying, they're good parents. They want their kids to follow the rules. They want to know what the rules are that their kids need to follow. And so if we tell them that, they will tell their children that. There will be situations where their kids don't follow those rules. But
I just want a little clarity between now and then.
You know, I have no objection to it applying to charter schools. The charter schools might.
I suspect they might. But we can follow up. We'll have another conversation about that, Rep. Jefferson.
Thank you so much.
Representative Brass for a question.
Yeah, thank you, Mr. Chairman. One quick question. Actually, I had a few, but most of them have been answered already. But if I can bring your attention to page 2 or 4 of the document, I don't know if you guys have it in front of you, where it reference the hearing as far as once a kid is
which line?
25.
I guess 22 through 27.
Mm-hmm.
It references where the kid has been suspended or recommended for expulsion. The amount of time, the 30 days, is that the norm as far as a suspension in which a hearing has to be scheduled? It seems long, just kind of thinking of it in Camara's perspective, his situation. He's already gone through a couple weeks to get to the point where he's been expelled. So then look like the parish authority or the school system has an additional 30 days in which they're required to have a hearing. So that's almost 6 weeks. So is that the norm with expulsions?
The law right now provides that after the due process hearing, which is with the superintendent, first level is with the superintendent or his designee, they can request a hearing with the school board within 5 days. But the law does not require that hearing to occur within 5 days. They have to request it in 5 days. And then I would assume it just goes on the school board's next agenda, or I don't know how the school boards actually, but I would assume they put it on their next time agenda. Here, we were trying to be sensitive to the issue of not knowing how many hearings might need to be conducted. Certainly there's no objection on our part if you reduce that amount of time. I think that, hopefully all the school boards will just go back and look at their policies and do the right thing and try and get these kids back into, a situation where the status quo was before they took action against them and take that initiative themselves. 30 days seemed like a reasonable amount of time, being sensitive to the fact that we don't know how many cases there are.
Okay. And what's the appeal process for if a student is deemed, if it's not overturned, but upheld by the school board? Is there an appeal process for maybe Betsy or some other type of local entity?
The system now allows them to appeal if they are recommended for expulsion. Our interpretation is that whether that is reduced to a suspension or not, that they are allowed to appeal to the school board within 5 days and then seek judicial review, which they have to request within 10 days. So there are some short time limits on seeking review. And the interpretation that's been given by the school board is that if they reduce that at the end of the initial due process hearing to a suspension as opposed to actual expulsion, that it stops there. So this amendment that you are putting on the bill today clarifies that when there is a recommendation for expulsion, you get the appeal to the school board and you get a judicial review, because we have put these consequences in the law that don't just follow the expulsion being converted to a suspension. His record remains the same. His record still shows a gun charge or a drug charge or a knife charge. And so parents certainly have a good reason, the way we have built this system, to want to seek judicial review or to seek school board review, even if at the due process hearing it was reduced to time served suspensions, because the record follows them. And if it's a gun charge, they may get sent to the district attorney's office. So, they may have a gun charge that travels with them for a long time. So I think that given the way that these laws have been written, it is appropriate for them to have a hearing before the school board where the school board could take further action, and then seek judicial review if they desire to do that. That's the system the way it is now.
Okay. My last question, Mr. Chair. It concerns me because you've mentioned a couple of times that Camara had felony gun charges on his paperwork. Currently, what is his situation as far as the legal documentation, his history, where he's at in the school process as far as appealing his expulsion? Because I asked the question because I would hate to see 4 weeks, 6 weeks from now, Camara is still not in school. He's still going through this process. So,
right.
With that being said, how can we as an education committee be engaged to ensure that he's going through due process with Jefferson Parish School Board? Do we need to request them? Okay.
I mean, this bill basically cuts to the chase and says he gets a hearing. It resolves any ambiguity in the law or any perceived ambiguity in the law, because we didn't think it was ambiguous, but to the extent that it was, we think that should have been read in favor of the child, not the school board.
So he's not in school now?
He is in school. He's back in school.
Okay.
I know there was one other child not in that school system, in a different school system, who was actually directed to alternative school. He was expelled, and I had reached out and that child now has a lawyer, and they are taking the right steps to protect that child and to remove this from his record, get him back in his prior elementary school. He's 11 years old, and to put him and to go deal with the charges that have been referred as on a Title 14 crime. I mean, so, again, it's not just Camara's situation. Camara's lawyer has filed a lawsuit. I think that they've received some relief by getting a TRO issued by the judge that stops this, at least any further actions against this family. He is back in school. He has been, since their due process hearing. But I think, there are other kids who might not be. Or who might be in an alternative school, and I think that this will give them the ability to get a hearing before the school board and potentially have that reviewed by a judge if they wish, and to find a lawyer who's willing to help them do that.
Okay. Thank you, Mr. Chair.
One thing, if I may add to that is really important for someone that just experienced this week, is that what Liz keeps saying is that the first stop is the superintendent. But keep in mind, it's a superintendent's
Mic's not on.
Which is in this case, and
Excuse me, man. I hate to interrupt you, but I don't think that microphone's on.
I don't think it is.
It is? I can't hear it.
No, I don't think it is.
I don't think it's on. You want me to just yell?
No, we're broadcasting, so you have to be on the mic.
So one thing, as someone that just experienced this, is why this is so important to grant the second level for these serious charges, is that it's not the superintendent looking at this. My guess is that the superintendent learned about this several days, maybe learned about it on the front page of the paper. It was his designee, which was a hearing officer, that directed the due process hearing in a manner that was entirely inconsistent with due process, couldn't answer any of my questions about due process, couldn't answer my questions about policy or procedure, indicated to me that they did contradict the policy and procedure. And since that date, I've had 5 people call my law firm about this exact hearing officer since I've sued her, and indicated that my child also did not receive due process from this hearing officer. So it's not the superintendent, it's his designee that gets to determine on behalf of the superintendent. And that person is not well versed in the law, and that person does not know the specific policies and procedures. They just look at the revised statute and then tell the superintendent, do this, and then it ends. So if you can get to a school board of numerous people, then more people can come to the table and look at it fairly. And even at that step, they may not even decide to hire an attorney. They still have a second body level of review. And that's why it's so important, because the superintendent's designee, we're finding across the state as a result of this case, are untrained in this area and in this statute as applies to policies.
No
and
question,
procedures.
your actions, not only in this committee today, but also in court, are going to help to remedy that situation as well. So.
And as Liz has stated, we did seek a mandamus on this, but to me, the writing is clear, but you can only bang your head against the wall with other attorneys as many times as you can on your own interpretation of it. And their interpretation is that the law is clear the other way.
I get it.
So we really appreciate you taking this under consideration.
So is that the norm, where the school board is the ultimate, makes the decision maker? To me, if I was a school board member, I wouldn't want that, because ultimately you're politicizing it. So if the student is from my district, I may be less hesitant to expel him because he has a big family in my district. So is that the norm, where the school board makes the final and last decision?
Well, the norm is upon a expulsion, they have 5 days to appeal it to the school board. That is the law. What this school system has done is said, we recommended you for an expulsion, but because we didn't expel you and suspended you, you don't get that 5-day guarantee that kids that we were straight out expelled did. But you still have the gun charges all over your record. So yes, it is the norm. So step one, superintendent, within the superintendent's decision to expel, you have, or to reduce to a suspension, as the Solicitor General and I are arguing, you have 5 days to then appeal to the school board. And then within 5 days of the school board's either decision or denial to hear it, you then have 10 days to go to the district court. So that is yes, it is the norm in expulsion cases for the school board to be second in line, as the law states. And so we were trying to get to the school board, but we got blocked there. And I personally emailed every single member of the school board multiple times. And I had members of the school board call me and tell me that they stood with the Harrison family, but their hands were tied because of the attorney's interpretation of the law.
But that's not, I want to be clear that we read the law. We think the law says we don't think. It does say upon recommendation for expulsion, this happens, X, Y, and Z. This interpretation is coming in because the school board, because the superintendent does have some discretion to reduce the charge in certain, and with gun, knife, and drug charges, the law is very restrictive. It has some mandatory expulsion recommendations, like the principal, if it actually is a gun in school, then the principal has no discretion. It is a mandatory recommendation for expulsion. And so the laws allow some back-end flexibility on a case-by-case basis, and that depends on what age you are. We have a kind of a full discretionary mechanism if it's in a car and it's safely stowed and not being used in a threatening manner, which I think clearly recognizes our sportsman paradise issue. And we've written very draconian system. We've written a very, very restrictive system with some back-end exit ramps built into it for guns and knives and drugs. But the charges will stay on the record. There's some other consequences that also attach that have been built into the system, regardless of whether they've been expelled or not. And so, I think that you have to look at that system in totality, and the totality of what happens to a child. And we view that as being appropriate to allow that full level of review. Doesn't mean they're going to win. It means they're going to get review. And so there's still a large amount of discretion built into the law to school officials, and to exercise discretion to be able to manage what's happening in their school systems. And, so I don't think that we have a very, very egregious and sympathetic situation with Camara and with Mr. Brown's situation and several other situations that have arisen because of the virtual school environment. But the law right now, the way it was written, wasn't written for that environment. It was written for the physical school and school-sponsored events like the prom or a football game, or where you have a lot of people who are present, and so we have made them very restrictive for a reason. But if what you're keying into is it's a strict system, it has consequences down the line for kids, and right now the way the law is written is when it's a suspension, it is final after your review with the superintendent. There is no further review. The decision is final. And so it doesn't go to the school board after that. And this is where we're trying to sort of make the law clear that, or even more clear than it already is, that upon recommendation for expulsion, you get to go all the way through, because it's not over, even though you may have converted the actual school consequence back to a suspension.
Okay.
Okay, Representative. Oh, one more question.
Just for clarification, are the felony gun charges still on Camara's record?
Camara's record right now says that it was brought a facsimile weapon to school, which
Well, I don't.
There is no.
So his record indicates his Louisiana student disciplinary report is comprised of 3 pages, which will be in his student personnel file. The first page says possesses weapons prohibited under federal law, location, classroom, or other. The second page says possesses weapons prohibited under federal law. The third page says possesses weapons prohibited under federal law. That is going to be in his student file. On the back end, they changed it to possesses a facsimile weapon on campus. When I asked about it and said, this needs to come off of his record, the attorney wrote to me, and this is in the petition that you'll get today, quibbling about clerical errors in paperwork will not go very far when the student has received far more process than is due under such circumstances. Camara received more than sufficient process to satisfy the requirements of the state and federal law. I cannot and will not recommend board review of Camara's suspension, nor will I recommend expungement of his record, because the facts are simply not as you have presented them in your similarly unprofessional efforts to litigate this matter to the press.
If you would send us a copy of that letter.
It's already, my staff has already sent you.
So ultimately, that's going to follow him?
This will be in his Louisiana disciplinary board is going to follow him, and then his record indicates possesses facsimile weapon in violation of on-campus guns policy.
And Representative Brester, I know of at least 2 other cases where the records say brought a non-federally prohibited weapon to school. So those records say this child. That's what in at least 2 or 3 other particular cases that I personally know about. Those records, they were converted to time basically out of school already by the time they got to their due process superintendent or designee hearing. And so they let the kids back in school, but their records say that they brought a non-federally prohibited weapon to school. But I mean, the record says they brought a weapon to school. And that's just a pretty egregious thing to have on your child's record when, and that's why these parents are so frustrated, because they, for one thing, it's not a hurt in that case. It's not it's not a federally prohibited weapon. I mean, I think that what that referred to was the Federal Firearms Firearm Free Zone Act. I mean, maybe that's what that referred to. It is not clear, but the charges are supposed to be clear. To give fair notice of what you're being charged with. And in the other cases, they're saying non-federally prohibited, but it's still a weapons charge. And in one of them involved a knife and alleged knife. And I think that it triggers all these egregious automatic expulsion recommendations. And it has the same problem where on the back end it's cut off to a suspension, time served. That discretion is good discretion, but it's not. It's not really wiping the kids. It's not giving the child a good opportunity or any opportunity to go back and clear his own record, or his parents to clear his record, and because the school's basically saying that's final. Okay. And I think it's fair for parents to be concerned about what follows their child's permanent school record. It's going to go into, it could be in you have to answer questions like that on job applications, on college applications. There's just so many ways that this will affect their futures. And the fact that, I mean, we should at least be able to give them a chance to talk to the school board and maybe a judge. This is not, doesn't mean they win.
Chairman, I would like to ask that maybe you and I get together offline to where we can come up with a strategy to where we can do a follow-up with this piece, because I would hate to just linger and that just to follow him. Maybe if it's calling Jefferson Parish Superintendent, Chairman, School Board to give a testimony or come before us,
Sure.
House Education Committee, or to request a full
I do want to
report.
advise y'all that there is a little hiccup with Kamari's case. I did file a temporary restraining order and an injunction on this, but it is an empty seat and a pro temp judge. And while you're ordinarily granted 2 to 10 days, they want, for continuity of the case, they're not going to hear it until November 4th. So as it sits, I can't do anything about his record until November 4th other than have a TRO. So if you can act sooner than that, that would be wonderful.
We'll definitely do that, Representative Barres. And I do have a text from Jefferson Parish that I'm going to read into the record in just a minute. But certainly anything we can do to correct the situation. I think the bill has some teeth in it that will help that. So first thing today, we need to get this bill out of here.
I don't want that to linger.
No,
and I don't think that bill addresses his issue.
I don't think any of us do. And we have to make sure that that's not going to be an issue that's going to haunt him in the future. And members, this is not directed at you, Representative Freiberg. You're next up. But we do. It's lunchtime. I just want to make sure you. First, I want to apologize for working through lunch, but we do have to be on the floor at 2, and we have several bills left. So, to the extent you can keep it concise, I'd appreciate it. Representative Freiberg for a question.
Thank you. I would be concerned if not just about Camara, but the other folks. That are in the same situation. So I would want to make sure if we do something that we do it for all. My question is probably to Joan Hunt, if she doesn't mind coming to the mic. Rep. Jefferson asked the question about charter schools, and I would have to assume that charter schools are public schools and this would apply to them. Do they have to turn in every year a discipline plan to Bessie?
They first, charter schools, 17416 as it's currently written does not apply to charter schools. They do have disciplinary plans, yes, and those are provided to their authorizer. Of course, not all charter schools are authorized by Bessie, as you know.
All right.
So,
but the ones that are authorized by Bessie, do they have to do discipline plans?
They do, yes.
They do. So Bessie requires that they do them. How about our online charters? Do they have discipline policies in place?
They do.
They do.
Yes.
So that might be a place that school systems could go to look at what already schools that are K-12 virtual, the policies that are already in place, they might look at those as guides for development. Since we have a December deadline for school systems, there may be things that a school system that hasn't been doing virtual for years might gain some information and some guidance from those. So those were my questions.
I think that's
Thank you.
Yeah, it would certainly be a good starting point, right?
Thank you. Yes.
Representative Ahmadi for a question.
I actually had a question for, I don't want to massacre her name.
For real.
Cusimano?
Oh.
She just stepped out for a minute.
Okay. Well, you could probably answer too. I just wanted to ask, when this is all said and done, as we've been hearing right now, if nothing changes, this issue is going to remain on this student's record, as many other students have the same experience. What remains on the records of the employees who have abused these procedures?
I mean, that's beyond the scope of the bill, other than I think I can tell you of a couple of consequences, and the law already provides teachers, principals, school superintendents who are sued in the system with a defense and indemnity when they're, carrying out their job duties. So, I mean, I don't think anybody was really critical of the teacher or the behavioral therapist who did follow protocol and report what they saw. It just sort of went downhill from there.
Exactly. At some point, somebody went to an extreme.
They can lose their indemnity under the law if they are engaging in intentional conduct that is, so that is one part of the way the law already reads, that the teacher or the people who are being indemnified can lose that indemnity. They're entitled to it on the front end. That means that they are given the good faith trust that they are acting in the course and scope of their employment, but and that they are, in good faith and doing what they think is required of them under the law. They can lose that indemnity. So that's one consequence. We don't have anything built into this bill that addresses that. Our focus was really on trying to make sure that schools did go back and write policy that covers virtual school, since we all went headlong into virtual school on March 13th. I would point out there is a statute that defines virtual schools, and all it really addresses is attendance. Right. And it defines a virtual school based on how the amount of schooling that is being delivered through an electronic platform. And by that definition, and Joan Hunt and I have discussed this, because by that definition, in my view, every single school in this state became a virtual school on March 13th. And there was the only policy, the only thing we really had covered in statute was attendance. And yes. Attendance basically said you can write, that you can have some attendance requirements. It's really a pretty vague directive anyway. So I think that, again, this bill is a good start. It may not be the end of this conversation. I hope that it's not, because I think that, we are not back in full swing yet with day-to-day schooling. There were only 2 schools approved by Bessie that were 100% virtual school approved, and everybody else all of a sudden started doing it. And now we're back into hybrid situations, and it is difficult. It is not just difficult for students and parents, it's difficult for teachers, and I think there's a lot of conversations to be had here, but let's start with this. And let's start by clearing the record of kids who may have been the victims of the grown-ups' failure to recognize that we didn't actually revise our policies for this situation. And let's go back and revise those policies. And let's make sure that the law is clear that when you are recommended for expulsion, that you can get a hearing before the school board under any circumstances, that you are allowed to get a hearing before the board, and you're allowed to take it for judicial review after that, because expulsion is the most severe consequence that the school system can impose, and we have added consequences on top of that for some serious charges. This would apply across the board for any recommendation of expulsion on that particular part of the bill, but it is appropriate based on the way we have built our disciplinary structure.
Well, thank you for elaborating. And I know that this bill does not handle my initial question of what happens to the employees that abuse the situation, because it just seems unfair that if certain things are going to be stuck on a student's record basically for the rest of their academic life, even if they're found not guilty, then what happens to the accusers who took it to the extreme? And we don't really have to answer the question here. I just wanted to ask it for the record so that it can be part of the ongoing conversation, because it seems that as we have Davids who are fighting Goliath, we want to try and handle the entire situation and make sure that it's fair across the board.
So I can speak to that very, very quickly. One thing that would be interesting in the future is we are alleged a defamation claim in this case, but there are component pieces of, a privileged third party, maybe looking at a third party issue of where can you report these crimes, and when does defamation step in and stop? Where does it not become a privileged communication? Where does that become defamatory in the future?
Well, thank you for letting us know you're already looking into it, because it's related.
All over this. It's like,
thank you.
Out of necessity.
Dog with a bone.
Rep. Amity, you're the last person in the queue. Do you want to go ahead and propose your amendment now?
Yes, sir. That'd be fine.
Go ahead.
Okay. I'd like to propose an amendment to simply add a name to this bill that would be we talked about Camara's bill, but it seems that staff has informed me that we really have to take a little more formal name. And so would Ms. Barnett, would you like to read that out and elaborate?
Thank you, Representative Amade and Mr. Chairman. All we would do is we would add a Section 5 to the end of the bill that says this act shall be known and may be cited as the Camara-Harrison Act. And that's just standard language that we use when we add what we call a short title.
Right, and I don't have a problem with the standard language because
Thank you so much.
in years to come, when Kamari is a young man and looks back on this, it'll have his full name and he can refer to it as needed, as the rest of us could. So don't object. I'd like to propose that amendment.
Not at all. It sounds wonderful.
Okay, members. I'm sorry? Something else? Okay, members, Representative Amade has proposed that we adopt the amendment that would name this bill the Kamari-Harris bill. Is there any objection to the adoption of that amendment?
Then
Harrison. Thank you. Thank you. Get that correct. Any objection to the adoption of the amendment? Seeing none, this amendment will be adopted. Back on the bill. We have no further questions in the queue. We have a few more people who wanted to testify. In the considering time, yeah, if we've already heard your issues, I'm sorry, Ms. Cusimano, you have something
Are
else
you
to say?
able to read the Jefferson Parish statement so I can at least hear something from them before
I'll get to it
driving
when I
Kamari
get.
home?
I'll get to it when I. Yeah, I'll get to it. All right, Mr. Brown, did you still want to testify, or did we state your case well enough? You're more than welcome to come to the table. Also in favor, would like to speak Cynthia Posey, Louisiana Federation of Teachers. Ms. Posey, do you want to come to the table? Also in favor, not wishing to speak, Kathleen Benfield, Louisiana Family Forum. Christy Cross, Louisiana Family Forum. Lance Maxwell, on behalf of Louisiana Attorney General Jeff Landry. And we have one card in opposition that we'll call up in just a minute. Ms. Posey, please introduce yourself for the record. Oh, Mr. Brown, I'm sorry. If you want to stand up.
My name's Timothy Brown. I live in Grand Isle, Louisiana. I'm a father. I'm not going to rehash the same thing. My son's 11 years old in 6th grade, the exact same story. It was even a Daisy BB, Red Ryder BB gun. This whole thing's ridiculous, and thank y'all for standing up for the kids.
Well, we're trying to do the right thing.
Right, thank you.
And sometimes, with the bureaucracy, I understand things get lost, but this is something that we have to do to level the playing field. I don't think there's any question about it.
Right,
And
a little common sense at the beginning of this, none of us would be.
absolutely, it would avoid people like you having have a lot of angst over these types of issues. But we appreciate you coming to testify today. Certainly, I know you'll be in touch with Ms. Cusimano, and if we have any questions, we'll definitely follow up with you.
Thank you.
Thank you. Ms. Posey?
Thank you, Chairman. Members, Cynthia Posey with the Louisiana Federation of Teachers. We are here in support of this bill. We do have one small concern that we've talked to Representative Romero about. It's on page 3, line 10, where it says the phrase, any school official. We would just like clarification on that, because as we've heard the word or the phrase use common sense repeated multiple times with this bill, we want to make sure, Kamari's teacher took up for him. She felt that by law she had to report it, but she took up for him.
Let me just make sure I understand you before you go too far. And I don't mean to cut you off, but this is one of the sections dealing with attorney fees. So this wouldn't punish a teacher, and it wouldn't do anything to the teacher, except all this section would be to allow attorney's fees in the case that even if it is a teacher, would allow attorney's fees. So it doesn't really have an effect on a teacher unless I'm reading it incorrectly.
Oh, this was flagged by our attorney, and so I just wanted, to seek clarification.
That's the way I read it, unless I'm reading it incorrectly. Is that the intent?
I think I understand that too. Is that it doesn't affect the teacher?
Yeah, we certainly didn't intend for this to have any effect on the teachers. But in the case that a teacher may, in his or her official capacity, act in a grossly negligent manner, then attorney's fees may be awarded in that case. So, and I think we're going to probably change that to a reasonable standard for the attorney's fees as well.
Good. Thank you.
Okay. Any other comments?
No, not at all.
Thank you for coming today and submitting the card.
Absolutely.
We appreciate that. All right. I have one card in opposition. Is present and will provide information if necessary. Doesn't necessarily want to testify. Is Wes Watts from LASS. Mr. Watts, you want to elaborate, or are you still here? Okay. Because what is LASS? State Superintendents Association. Okay, and we don't know what your objection is if you don't come and tell us, so I'll leave that up to you. And then for the record, I just wanted to read Jennifer Ansardi with Jefferson Parish did text me, and it's not an opposition, but JPSB's Jefferson Parish School Board wanted you to be aware that HB 83 directly impacts the situation that happened in Jefferson. Since litigation is pending, we are bound by confidentiality to protect the student and cannot provide information that may be helpful when deliberating. I'm not trying to read too much into this, but well, maybe I anticipate that this is the reason why they didn't come and testify today. I don't know. She didn't say. But I wanted to read that for the record because I thought it was pertinent. Please.
Yeah, and thank you. And man, standing here in opposition is kind of a strong word, because no opposition to Mr. Harris and Kwani and that whole situation. This is not directed at that situation. Concern being appealing all suspensions. Representative Brass brought some part of that. If all suspensions are now going to our school boards,
I don't read this.
Reading.
I don't read this that way, and Ms. Murrell can come back to the table and explain that. The way I read it is, if they're charged or if they're recommended for expulsion, and it's reduced to a suspension.
Okay. That was more for clarification. That's why it was the information.
Is that correct, Ms. Murrell? Is that?
The question was if it's recommendation for expulsion and it's reduced to a
His
suspension.
concern is, does this apply to all suspension recommendations?
No.
Okay, so my reading, my understanding, and I'm not a lawyer, was that all suspensions
congratulations.
could be appealed to the school board, and that was just a concern for us. And part of that would be what Representative Brass said, and some politicization by our school boards and decision making.
Okay, all right. So I hope you've had your question answered. Are you withdrawing your opposition?
Well, for now, yes, sir.
Okay, just wanted to find out.
Concerns that I'm not, but we'll get deep as we move along. I'm sure this process is ongoing.
Oh, no question.
Yeah,
No question.
thank you.
Okay, thank you, Mr. Watts. Okay, Representative Romero, you want to close on your bill?
Absolutely. Thank you for so much time. And I do want to mention that Kamari is a hero. I mean, he brought this forward. I just happened to meet the kid and his family in the bottom of the Capitol when they were here, and that triggered the thought process when I contacted the Attorney General, and that's what kind of got this thing going. And then Mr. Chairman, you got on board, which is very helpful. And I do want to thank Mr. Brown as well. You know, I realize that these are not the only two cases. There are others, and that we need to protect them and do what we can to represent the people of Louisiana. And once again, it's said over and over again, but Representative Jefferson said it best. I mean, it's common sense. We would have never had to been here had there been common sense done, or played into this factor from the very beginning. And I think that's important to recognize. And also that we're not here to hurt teachers or superintendents or students or families. We're here to make sure that there's a proper order in place so that the students and the parents have a place to go for appeal.
And again, I think Ms. Murrell said it pretty well. We're not trying to erode the school's ability to enforce discipline, but we are making sure that we have due process in that discipline process so that we kind of level in the playing field. Correct?
Absolutely. And with that, I'd ask it for favorable approval.
Okay. And members, because I've already co-authored, I'm going to go ahead and move that we report. Of course, I took my glasses off. Sorry about that. House Bill 83 favorably as amended. Are there any objections to reporting HB 83 favorably as amended? Seeing none, HB 83 will be reported favorably as amended. Thank you so much to everybody who came, you especially Representative Romero, for coming and bringing this. And I'm sure that we'll be working from now through the process to make sure that it's all correct.
It sounds like it, and that's what makes a good bill, is everybody's minds put together.
Absolutely.
Next bill is House Bill 83 by Representative Romero, relative to student discipline, judicial review of certain disciplinary actions.
Representative Romero on your bill.
Thank you, Mr. Speaker, and thank you, members. HB 83 attempts to clarify existing law to make it even more clear that if a child is recommended for expulsion, then the child or his parent or guardian has a right to appeal the decision to the school board, and after that to the courts if deemed necessary. It also requires school boards to comply with existing laws and review and revise their policies to account for the virtual instruction environment. It ensures kids who were recommended for expulsion based on virtual instruction issues, getting hearings, and can get lawyers to help them clear their record by granting reasonable attorney fees. Finally, it adds a new provision that allows reasonable attorney fees when a board acts vindictively or in gross negligence in the charges it makes against a child. What we're trying to do here, we're all aware that there's been a change, a major change in our lives, especially in students and teachers and those people that are trying to educate, by adding virtual learning. And it's come to the attention that we as legislators who represent the people of this state need to step in and try to determine the difference between education in a school system or in a school environment and education virtually at maybe home. And that's what this bill attempts to do.
Question on the bill, Representative Villio.
Thank you, Mr. Speaker. Representative Romero, who drafted this bill for you?
The AG's office.
Can you tell me any bills we've passed since the pandemic that created new causes of action, as your bill does?
I do not. I cannot. I'm not an attorney, and I don't declare to be one. But I cannot.
Do you know that in Louisiana, very few causes of action afford attorney's fees as redress, as your bill does?
I think, in my opinion, what we were trying to do was level the playing field. I understand that when an issue comes up, the school system, the teachers, and the administration has that right to be able to have those attorney's fees paid for, and this just levels the playing field and allows the child and his parent or guardian to do the same thing.
Do you know this body passed tort reform this summer? And I think you would probably agree that in large part the trial lawyers were pretty much maligned in those debates. And by creating a new cause of action for damages and attorney's fees, as your proposed bill does, do you realize that you're providing retroactively a potential lining of the pockets of certain individuals at the cost of our state's school system?
I do understand that, but I think it's important, once again, that we give an avenue for the children and for the parents that are protective of their children to have an avenue to be able to change a decision that's made by a school board.
Let's be honest. This bill is about an incident that occurred in my parish. That's what brought this bill. True?
The bill was brought because of that, but that's not who this is for. This is a statewide bill, and I would even contend that this is a nationwide bill. We weren't prepared as a nation or a state for COVID crisis. And now we're thrust into this, and we need to be able to develop a plan that allows students to know the rules as well as their parents, and for teachers and superintendents and administrators to be able to govern those rules. And if we give those people, the students, the rules, they can follow them.
Would you consider an amendment that removes the retroactivity and the attorney's fees?
I think that's part of the, in my opinion, it's part of how we solve this problem. Like I said, it levels the playing field. The retroactivity goes back to, I think what you're speaking to goes back to March 13th when the COVID crisis began. And we know that there are cases, a number of cases that are already involved from that time period forward. Those kids were not given the opportunity to be able to expunge their record or to be able to have an appeals process. And I think that they only deserve that right.
I want to be clear to see what you know about Jefferson Parish and its school board's policies, and be clear for this body. Do you know that Jefferson Parish School Board does not and did not have a policy that disciplined a student merely because he or she had a BB gun or any gun in the screen of virtual schooling? Are you aware of that?
I'm not aware of that, and I'll tell you that part of the problem is that because of litigation issues, we were not privy to be able to have that information. And I think that that we can certainly work on that to make this a better bill. But once again, I stand with the students and the teachers and everyone, and say that we need to have policy changes made for virtual learning that sets it all out in the open, so that people know what they can do and not do.
And to be clear for this body, are you aware that Jefferson Parish School Board policy did not and does not discipline a student for having, for instance, medication in the screen of virtual schooling, but rather it's the actions of the student that may or may not trigger discipline? Were you aware of that?
I'm not aware of that.
Thank you.
Question on the bill, Representative Gary Carter.
Thank you, Mr. Speaker. Thank you, Representative Romero, for bringing this bill. And we had the opportunity to have the family testify in education, right?
That's very correct.
And the family was outstanding. Mr. Harrison and his father, they testified about this egregious thing that happened. And it seems like common sense was just lacking from the entire situation. So thank you for bringing it, and thank you for bringing this bill. Thank you.
Thank you, Representative Carter. And I also want to mention, too, that this bill came out of committee unanimously, and it was vetted for 3 hours. It was they listened to the testimony, and I think made a good decision to bring it to the floor.
And I think it's most important, too, though, that it was very important for the father, Mr. Harrison, to stand up and speak up for his son. And had he not done so, this probably would have just continued out of sight. So I'm glad that the father stood up, and I'm glad that you brought this legislation. There's some tweaks in the language that we're working on between here and the Senate, but thank you overall for bringing this bill. Thank you.
Thank you.
All right, question on the bill, Representative Edmonds.
Thank you, Mr. Speaker. As a part of that testimony, this fourth grade student was expelled from his school. Is that not correct?
That is correct.
So before any other action, although you're reminding us we're in a virtual environment, and it seems like we're sort of caught in a new day. Is that not one of the reasons you're bringing this bill?
Yes, sir.
And so this young man was not suspended with any opportunity to return. He was expelled.
He was expelled originally, and then it was moved to suspension, which allowed for no process to appeal.
Right. And then along with that, there's not up to this point, to your knowledge, been any expungement of his record, as well as he has violated what was originally bringing a banned weapon into a school environment. Is that not correct?
As far as I know, that is
the testimony was stated that he was in his home. Is that not correct?
That is correct.
And so therefore, and this was we asked the question there. It was a Daisy BB gun. Is that not correct?
That is
correct. It was
correct.
a present from his father.
That's correct. A birthday
And
present
so,
that he got from his father.
Thank you for clarifying that, Representative Romero.
Question on the bill, Representative Jefferson.
Real quickly, Mr. Speaker, thank you. Representative Romero, thank you so much. Let me join everybody else on the committee for bringing this piece of legislation. But can you expound just a bit? Because one of the good parts of it, and there's several good parts, and as Representative Carter indicated, a few areas that need to be tweaked regarding the online instruction. This is new territory, correct?
It's very much new territory.
And is it mandating to the various districts the criteria regarding online instruction?
It's mandated that the criteria be looked at every year, but it's not. Some of that is not done, and this bill actually it mandates them to be able to look at this and make rules for virtual learning. I mean, that's the whole problem here, is that we're in a new. You hate to say a new normal, because I don't like those names, but we are in something different, and that's been since the COVID crisis, and I think we have to address this to move forward.
And I think the last part I was going to say, this is a new area, and it gives them an opportunity to come up with some criteria, et cetera, because it was not on the typical normal school grounds. Is that correct?
That is very correct, and I think you bring up a good point. This is something new on both sides. This is not against the teachers and principals and superintendents, and it's certainly not against the students and their families or their guardians. This gives direction on both sides so that everyone knows where we're going and what the rules are, so that we can move forward.
Thank you so much again. Thank you, Mr. Speaker.
All right, Representative Phelps for questions.
Thank you, Mr. Speaker. Thank you, Representative Romero. 2 questions. Were there other students throughout the state that have had this same similar problem with other incidents that were deemed a lot more extreme than what the event actually was?
I don't know
Besides
that
just
it-
this one incident, have there been others
Oh,
throughout
no,
the state?
there have been other incidents, but I'm not privy to whether it was more extreme or not more extreme. But there are other incidents, yes. As a matter of
And-
fact, in the testimony in the committee meeting the other day, there was a Mr. Brown that testified that his son had some of the same issues.
Okay, thank you. And were there, was Attorney General Landry's office able to clarify the law where you were able to even bring this legislation where they were able to clarify the law for the schools, for the districts, to where it's interpreted correctly?
I'm sorry, repeat the question again?
Was Attorney Jeff Landry's office able to identify and clarify the law to give clarity to the school systems of what they misinterpreted on situations like this?
I don't know that I'm privy to that information.
But
I know that there was negotiation, there was talk between Jeff Landry's office and the child that we're talking about.
The representative that spoke at the committee, were they not
yes.
able to testify that the school systems misinterpreted the present law?
Yes, they certainly did.
And they were able to rectify that with giving them more clarity of the present law?
Most certainly, yes.
Thank you.
All right, no more questions on the bill. Let's take up an amendment that we have. Madam Clerk.
Representative Garofalo offers up a two-page set of amendments, number 466.
Representative Garofalo on your amendment.
Thank you, Mr. Speaker. Members, this amendment does three things to address questions that were brought up in committee. Number one, under the original definition in the bill of virtual instruction, it could have been misinterpreted to mean only instruction that occurred on campus. We wanted to make sure that if the teacher is on a different campus or at home, that's included in the bill. Number two, it requires that the attorney's fees be reasonable, as opposed to just stating attorney's fees. And number three, we've clarified it. We've moved some of the sections around to show that part of the part that's dealing with the COVID crisis only applies to the COVID crisis, and that after December 31st, the school districts will each invoke their own discipline policy, but it requires them, the original bill requires them to bring up that original, their own policies and develop their own policies for virtual learning. And that's what the amendment does. With that, I'll take questions.
All right, there are no questions. Is there any objection to the adoption of the amendment? Seeing none, the amendment is adopted. Back on the bill, to the floor on the bill, Representative Amy Freeman.
Members, I rise in support of this bill. I want to remind you, I know it came out of one case in Jefferson Parish, but Camara is a 4th grade student, and he was in his own home. From this particular case, and the attorney lives in New Orleans, and she took this on as a pro bono, thought it would take a couple hours situation. From this case, 12 other cases have arisen, some outside of Louisiana, but 4 of those in Louisiana, in Jefferson Parish and East Baton Rouge Parish and other places throughout the country. So I rise in support of this bill because this law will allow for a second-level review of the case and other cases like this in our state, because I don't think it's fair for a 4th grade child to have a permanent record for a weapons charge that will follow him for the rest of his life. I'll remind you, this is dealing with children and a child in his own home. So I rise in support of the bill. Thank you. Thank you, Mr. Speaker.
All right, to the floor on the bill, Representative Edmonds.
Thank you, Mr. Speaker. I rise in support of this bill. Very few times do we have the opportunity to really pass a bipartisan piece of legislation. Sometimes we just miss. Sometimes we just choose to disagree. But sometimes we get it right. After we heard testimony from Camara and his father, Mr. Harrison, every member of your House Education Committee members, every member co-authored this bill. They saw something and felt something in their heart that you don't always get to feel. That is this. Sometimes something's done in a way that there's no other way to fix it. Sometimes an injustice is done. I, as you, wish we could fix them all. What we can do today is stand on the side, show our support for a fourth grade student in the state of Louisiana. I hope that this young man will recognize that this legislature has stood behind him, beside him, and that one day he'll be a great leader in the state of Louisiana. I'm thankful that I was able to sit in a meeting and watch the tears of a father as he sat there and loved his son, had no place else to go, and he found the Louisiana legislature. I was honored to be on the Education Committee a few days ago. After that committee meeting, Representative Jefferson and I had just a small conversation. He said, you know, you come in and out of these special sessions and sometimes we wonder, what in the world are we doing? What are we going to accomplish? Maybe this is just a waste of our time. And Patrick said to me, I know why I was here this special session. It was for Camara. It was for his family. It was for children that at times find themselves with no one to support them. So today, I ask you to join with me, Representative Romero and others, as we do the right thing for a fourth grade student, and we can feel good that we as Louisiana legislators have got it right. Thank you.
Representative Amadi for the floor.
Thank you, Mr. Speaker. I wanted to come down to the well in support of this bill because I was also in House Education last week when we heard the bill, and I was also very moved and impressed to see what I consider to be a wonderful example of a Louisiana family come into the committee meeting after a very difficult ordeal, one that's actually still ongoing. This isn't settled yet. It seems shocking to me that here in Louisiana, a student who happened to have a Daisy BB gun in his own bedroom has had to endure so much punishment. A Daisy BB gun. This is Louisiana. This is sportsman's paradise, you know? I was so excited to see that a daddy actually bought this BB gun as a gift for his son. I hope they get to go out and make use of it. I wouldn't want him to be punished for this, and yet he was. And he was punished for it because it seems that somewhere along the way, a school official forgot that your home is your home first, even when school is going on in your home. It's not an extension of the school in such a way as to have all of the school rules, like no gun zones and stuff, apply to your home. It's your home first. It's your private home. So it's just shocking that someone's privacy was invaded to this extent. And then we find out through the hearing, not only was he punished for this, but this punishment, even once it's resolved, if we don't act, is going to stay on his permanent record. A 9-year-old, for the rest of his life, is going to have a weapons charge on his record because he had a BB gun in his bedroom? This is disgusting. It's truly an injustice. So it was wonderful to be able to have a thorough hearing in House Education. And what's just as disturbing is the fact that he's not the only one. That there are many cases similar to this one going on right now in Louisiana. So I rise in support of this bill. I like it so much. If you look under my name, I proposed one identical to this. It just so happens that Representative Romero pressed his button first, so his bill had a lower number, and that's how it goes, and that's okay with me. So I've asked to be a co-author on this one. I ask for your support.
All right. There are no more questions on the bill. Would you like to close, Representative Romero?
I would, and I'd be remiss if I didn't thank Representative Amity, because if you notice at the very end, she amended this in committee, and if this goes through the process and gets passed today and on through to the governor's desk and signed, it'll be known as the Camara-Harrison Act, and I'm very proud of that.
All right. Representative Romero moves final passage of the bill. All those in favor vote yea. Those opposed vote nay. The clerk will open the machines. Members, vote your machines. Davis, yes. Stefanski, yes. Presley, yes. Hughes, yes. Garofalo, yes. Amy Freeman, yes. Green, yes. Newell, yes. Lacombe, Duplessis. Through voting, members? All right, close them up. 96 yeas, 0 nays. The bill is finally passed. Representative Romero moves to adopt the title, moves to consider the vote by which the bill is finally passed. Lay that motion on the table without objection, so ordered. Let's open it up for co-authors. Co-authors, members, vote your machines for co-authors. Co-authors. You through voting? Selders, co-author? Yep. All right. Davis, co-author. All right. Close them up. 63 co-authors.